Hey out there, legal warriors, how to get your shoplifting or theft case dismissed. If you've got that type of situation or know someone who does, or maybe you're just curious, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 25 years. And I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, I was always just jumping right into it. There's no such charge in Washington State called shoplifting, but people say shoplifting. The charge, if you sort of take something from a store or anywhere else, it's called theft in the third degree. And so the most common shoplifting case is theft in the third degree. It might be from a mall, Alderwood Mall, Bellevue Mall. If you're local to Western Washington, it could be from a Walmart or a Target or a grocery store. But in any case, typically an officer will get called and they'll usually give you a citation, a complaint for theft in the third degree. And they'll often tell you, hey, you're going to get a court date in the mail. Sometimes there's going to be a court date on the top left-hand side. And as long as the value of the property is less than $750, the charge is theft in the third degree. A caveat is if it's over $750 by a bit, maybe, there's no rule of thumb, but most cities at least will maintain and charge theft in the third degree if you're not much over $750,000, $1,200, just because they know if they send it to the county for a felony charge, unless you have a really bad history, the county's too busy. They're not going to file that. They're going to send it back anyway. And so that's what theft in the third degree means, taking property without paying for it, someone else's property, valued at less than $750. So let's say that's happened to you or your loved one. They caught me red-handed. I can't have this on my record. How can I get this case dismissed? And there's several different ways that people can get their case dismissed in the theft case. The most common one is something called compromise of a misdemeanor. RCW 10.22.010 is a law that says if a victim has a civil cause of action and they appear in court, we say that means in writing, and state they've been civilly satisfied for their damages, upon motion of the defense, the court in its discretion can look at your record and circumstances and decide to dismiss the case. It's not a right. It's not automatic. The prosecutor can object or not, but we don't need their assent, their agreement. I'm using fancy legal words there. So in most cases, you will get after you get stopped for shoplifting, you get that citation, or they say they're going to give you a court date in the mail. Then separately from that, there's this law in Washington State I call it the shopkeeper statute, that says, hey, if you're a store and someone takes something from you, steals something from you, you have a right to go after that person for liquidated damages. That means you don't have to prove how much your damages were. You can ask for so much money plus the cost of the items under the shopkeeper statute. And we really like that. We want the store to ask our client for money. Seems so weird, right? But we'll even call the store if we have to and say, hey, how about those damages, right? Because that's their civil cause of action I just mentioned in the compromise of a misdemeanor statute, right? If we can get them to sign a release showing that we've paid those damages, sometimes it's hard to get them to sign the paperwork because it's usually an attorney represents the corporation. They might be in New York or Florida or somewhere. But if you're dealing with a bigger firm, we usually have some connections from doing a lot of cases. But if we can get them to sign something, then the attorney, whoever it is working on your case, can file this motion with the court asking to dismiss it. Now remember, it's discretionary. If you got 5 prior thefts, the court's probably going to say, no, I'm not going to dismiss this. This is your 5th time. But if you don't have any prior record and not much of one, there's a very, very, very good chance the court will agree and dismiss the case. Because remember, we're trying to get rid of cases if we're in court. The prosecutor is, the judge is, there's too many cases. So compromise of misdemeanor is the key thing. And there's some practice pointers there. Don't pay it yourself, okay? Give it to your attorney to pay because the attorney can draft the release. The attorney hopefully has experience of knowing how to get someone at that store or the law firm representing the store to sign what they need to have signed. It's pretty tough sometimes, but that's a great way to get a shoplifting or theft case dismissed. Other types of theft too, right? If you steal from your uncle says they've been satisfied and you file it, you might be able to get it dismissed that way. What's the second way that you can get a case dismissed? Well, usually it's through something called an SOC, a stipulated order of continuance. That's what it's called in most courts. In Seattle, it might be called a dispositional continuance. In Everett Municipal, it might be called a POD, prosecutorial offer of diversion. So I need to have an attorney who practices a lot of areas so you know what to expect. But it's sort of like a contract that the prosecutor can offer you to let you earn a dismissal by usually staying out of trouble, maybe doing like a theft awareness class or some community service or something that shows that you can benefit from this negative situation, show it won't happen again. If you have prior thefts, we're usually going to suggest you to do some type of psychological counseling. What I found in my line of work, defending cases for 25 years, is people that steal something that shoplift, they usually don't plan on it. They usually don't know why they did it. It's usually done to change either an emotional or a bodily feeling, and they feel terrible about doing it. It sort of releases some type of change in the body, and that's why people act out of character. And if we've got some priors, maybe it's time that we look at counseling to address the underlying causes as far as what's going on. So that was a weird flash. Is it still filming?
Weird.
Or did it stop?
That's strange.
Okay. To address what's going on. So if you have some good affirmatives, then your defense attorney hopefully can go talk to the prosecutor who has a certain culture, certain ways, certain things they can do for theft cases, and try to ask them to give you this opportunity to keep from having a theft conviction. Because a theft conviction can be pretty negative for employment and housing and stuff like that. And don't say, on my record, right? There's always going to be a record you were in court. Big data collects everything. What we're trying to do is stop you from having a conviction. What is the third way we can defeat a theft case? Well, this is the hardest way. The third way to defeat a theft case is on the facts, FACTS, on the fact pattern. So you have to have a case where perhaps there was no intent to deprive the store. You can think of that, right? A scanning mistake. You know, I was just at a gas station this weekend, and I was really distracted. We've had some terrible tragedies happen in my family, and it was a gas station I wouldn't normally go to. You know, I'm normally a Costco guy. So I went to this other gas station. I pulled out my card. I tapped it on there. It beeped. I started pumping. It pumped. And then this guy comes out from the gas station and tells me, hey, your card didn't take. Make sure you pay inside. And let me tell you, if he didn't come out, there's 0% chance I would have went inside to pay because it pumped. I tapped it. I heard it beep. And I just thought right there, if I drove away, the $80 I paid for gas, I'd have been charged with theft in the third degree. So how could I have defended it? Well, that might be one of the factual defenses. Was there any intent to deprive, right? I attempted to pay, right? It acted like it paid. Now, they would say, no, you didn't. You were just faking. It was all planned. But that is a case where we might have a factual defense. Same way with a self-scanner, right? You know, I remember I was at PCC one day. Man, I'm almost getting charged with theft all over the place. So at PCC, and I wasn't sure something scanned, right? It didn't seem like it was enough money. You know, I didn't realize till I walked out. So I actually came back in and say, hey, was that enough? They said, yeah, it did scan. But I thought to myself as I was in the parking lot, crap, you know, did I miss something? It didn't seem like it was expensive enough because, you know, if it's PCC, it's as bad as Whole Foods, right? Your whole paycheck. So that's the third way. But usually we should not be asserting innocence as defense to a theft because the prosecutor's deaf to it, right? People try to steal in so many ways, the prosecutor's deaf to it. We can whisper that, but we want to work on the first two ways, or the main ways we're going to do shoplifting or theft charge dismissed. So that's what I could tell you. I hope you found it useful. If so, please like and please subscribe. More people get to see it. And more importantly, if you got a criminal matter in Washington State, feel free to reach out to my firm. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.